If you choose to name multiple beneficiaries, can you do so without creating conflict? Just remember that choosing your beneficiaries is more than just about money. It's also about your family, your values, and your legacy. But let's talk about it. I'm Valerie Zammitti, law and estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you're seeking any help in the estate planning world or in administering an estate after someone's passing, you can reach out to us for a free consultation at yourplanningattorney.com. And speaking of value, we are also here to educate you for free on a regular basis. So ask questions so we can answer them. And don't forget to share so that together we can help some folks along the way. Now, when you have multiple beneficiaries, you can create some fairness and certainly some flexibility. You can have equal distribution to avoid any kind of favoritism among parties. You can also customize what each person will receive based on circumstances. Say one child is involved in the business and the other lives at the family home. You can have some unique traits that make sense based on your family's situation. I say the best way to reduce any conflict when it is not just a completely equal distribution is to make it clear what your wishes are and how you came to those conclusions. And even better yet, have a discussion with those family members ahead of time while you're still around. Now, the challenges that come in with multiple beneficiaries, there is a potential for disputes, especially if there are unequal shares being distributed among the parties. Let's say, in my example just before, one child gets the business that they're involved with and the other gets the home where they've been continuing to live in. But the values at one point maybe were equivalent, but now they're very different. That could create a problem. And when you have a more complex asset division, right, or assets that are hard to divide, and for all intents and purposes, real estate can be complicated if there are too many owners at once. But I would say giving as much flexibility under your estate plan, making sure the counsel you work with creates that flexibility and is also then available, or a comparable professional is available at the time when your plan needs to come into play at your passing, where they can guide that process, right? Let's just say you have 4 children, happens to be my family makeup, and there's real property, right? If one particular person wants that property, well, the council will normally guide them to say, okay, what is the current fair market value? You will have to pay out your comparable or the comparable portion that would otherwise be due to the other beneficiaries should you want to receive that asset. Or if there's enough assets overall, they just receive less of something else. That's always a possibility as well. So these things can be resolved, but they have to be thought through ahead of time when you're doing the planning and then having guidance at the time when it's coming to fruition. Now, on the legal and tax side, right, inconsistent beneficiary designations may cause delays, but only in the sense that there's a problem that arises from the beneficiaries. It doesn't really matter if your distribution is 30% to this person and 70% somewhere else. That shouldn't cause a natural or regular delay. But again, and I think one of the questions that may have come from this, the reason we have this outline today is the question that arose was asking if there's going to be more taxes when you have more beneficiaries. Taxes, again, is a very, very broad term because there's a lot of different types of taxes. And you have to determine what type of taxes could be imparted to the family after someone's passing based on the circumstances. For instance, if there is a child who lives in the family home and has for some period of time, and they're going to receive that home as part of their asset distribution and inheritance, they, as a resident of that home, will have what's called an estate, or not an estate tax exclusion, excuse me, an income tax exclusion for capital gains purposes. If they go to sell the home, they'll have a little benefit. In addition to some other, tax benefits that would come to any beneficiary for property that has appreciated in value, like a home that has gone from, value X to value Y. That being said, there are also a potential for income taxes among the family members, and depending on what their individual income tax return level is, there could be income taxes to them, such as like retirement accounts. Okay, if your children, say, inherit retirement accounts from you, when they're withdrawing, it's going to be dependent on their own tax rate. So one child might be a little lower than another child. And so that comes into play too. Hopefully the counsel you work with in establishing your plan talks through a few of these things with you and gives you some insight as to best practices when it comes to the tax side. But best practices to avoid problems if you have multiple beneficiaries is to be obviously very clear and specific as to what your wishes are. An attorney should be able to help you with that. It's often best to use just like percentages as a whole. Not that specific bequests and like dollar amounts don't work in certain circumstances, but say you have 3 children and you want to give them percentages of the whole 100%, it works better that way. Do plan for the what ifs. This is something that, again, your counsel, this is what we do every day, is we talk about, okay, if beneficiary A is not there, then who receives instead? And if that person is not there, then who receives? And we kind of walk through all of those stages. And you as the client should think that through. Communicate your decisions, certainly, and I mentioned this earlier. I think the more open you can be and the more you can converse with your family about what you've chosen and why, the better off. Then there are no surprises. No one can second guess your choice, and it's very clear. Certainly, trusts become useful when you have a complex assets, even if it's not complex, but it's just you're looking for a little bit more of a seamless transition and to make it easier. Again, if there's a court matter that opens up because you have a will or no estate plan and it's going to go through the surrogates court, there's a higher likelihood that, not a certainty, of course, but a lot higher likelihood that someone who's a little disgruntled will file a claim because there's already a matter in the court. Whereas with the trust, that doesn't happen as much. Also, keep everything updated and consistent. Your estate plan, just talk to your counsel, review it every so often, make sure you have a conversation that it still works, meets all your needs and goals. So naming multiple beneficiaries is certainly possible, but you need to have clarity so that you can avoid conflict. Review your estate plan and seek professional guidance, of course. And peace of mind is possible. You can have a smooth plan for your loved ones as long as you make your wishes known. And they can carry that out as intended. Again, I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. You can reach us for free consultation at yourplanningattorney.com. I hope that you've learned something new here today. Please don't forget to share. And as always, take care. Bye-bye.